Have you ever encountered terms in Islamic studies that seem similar, yet carry distinct meanings and implications? It is easy to confuse certain concepts, especially when they are deeply intertwined and from the very fabric of a complex legal and ethical system. Understanding these subtle differences is key to appreciating the depth of Islamic thought. So, what is the difference between Sharia and Fiqh? Simply put, Sharia represents the comprehensive, divine law revealed by God, encompassing all aspects of life, while Fiqh is the human understanding and interpretation of that divine law. Think of Sharia as the ideal, the unchanging blueprint, and Fiqh as the human attempt to implement and apply that blueprint in diverse situations. The core mechanism behind this distinction lies in their origins and nature. Sharia is considered sacred and immutable, derived directly from primary religious sources such as the Quran, which is the holy book of Islam, and the Invalid, which are the teachings and practices of the Prophet Muhammad. These sources provide the foundational principles and ethical guidelines. However, these divine texts do not always offer explicit rulings for every conceivable situation that arises in human life. This is where Fiqh comes in. Fiqh is the jurist's human endeavor to derive practical legal rulings from those primary sources. It involves a sophisticated process of legal reasoning and interpretation, known as Invalid, conducted by qualified scholars. Because human understanding can vary, Fiqh has historically led to the development of different schools of thought, or madhabs, each offering distinct interpretations and methodologies for applying Sharia principles to specific cases. This dynamic process acknowledges the need for adaptable legal frameworks while staying true to divine guidance. To better conceptualize this, imagine Sharia as the grand, unchangeable constitution of a spiritual nation. It outlines the fundamental rights, duties, and moral framework. Fiqh then would be the detailed, ever-evolving body of laws, regulations, and judicial precedents created by legal experts to interpret and apply that constitution to daily life. One is the overarching principle, the other is its practical articulation. This distinction highlights a crucial aspect of Islamic scholarship, the ongoing role of intellectual effort and scholarly debate. The term ulama, referring to learned scholars, are central to this process, engaging in Invalid to address contemporary challenges while adhering to traditional sources. This intellectual dynamism has allowed Islamic legal tradition to remain as relevant across centuries and diverse cultures, demonstrating a nuanced approach to divine revelation and human agency. Ultimately, grasping the difference between Sharia and Fiqh illuminates the richness and flexibility within Islamic legal thought. It shows us that while the divine path, Sharia, remains constant as a guiding ideal, its practical application, Fiqh, is a product of continuous human reasoning and scholarly endeavor. This dual nature allows for both steadfast adherence to core principles and adaptable responses to the complexities of the world, offering profound insights into the development of Islamic societies.